And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law.
We have clients who already know about the power of attorney, already know about the healthcare representation agreement, but they don't know that if they put something into a joint holding with one of their children and they actually intend not to simply avoid probate processes, but they actually intend for that one child out of many children to receive that asset upon death, that maybe we should do a gifting letter. Maybe we should make that clear in order to protect it.
Can you give me an example of that?
Well, I have clients who have a separate bank account that they've always maintained for each of their children. And then two of their older children receive their bank account, they get married or they buy their first house. Their younger child, 23, still in university, hasn't touched that bank account. But mom puts it on jointure because she's thinking, now I'm getting older, I might not be around to write the check. My daughter might need to inherit that directly. Mm-hmm. And what if there's been a falling out between siblings? What if the estate isn't very large? What if the executor isn't familiar with those previous two accounts that have already flowed to the older children? Does somebody try to draw that account back into the estate and say that jointure was for estate planning purposes, it wasn't an actual gift over? So the gifting letter can make that very clear. So there's a number of different documents we might create. If we are writing out a child, you spoke of that earlier, if we are doing an inequitable distribution, I'd want a statutory declaration from my client setting out the whys and the rationale and outlining and identifying how they meet that test that Leah talked about, so that it's clear that they have provided fairly, justly, and adequately for all of their family, even though they're not attached to those assets. So
How high is the bar for that?
It's really dependent on several circumstances, but what Elyssa's talking about, so say the gift letter or the statutory declaration that provides an explanation as to why you're, say, disinheriting one of your children, provides for us, the estate litigators, a wealth of knowledge and understanding of what that willmaker was thinking at the time. So there might be very good reasons for someone to disinherit one of their children. And if you've set those out with your estate planning lawyer, then from our perspective, it makes it a lot easier for the estate litigation lawyers to understand what was at play there and hopefully settle the matter before it even, say, turns into a lawsuit. Mm-hmm. So that's one of the documents that you don't normally think of when talking about just making a will or doing estate planning that can be very important.
So you have a situation where, say, one child is not included in the will, and then you have this documentation to back it up. And once they've read it, they go, well, there's really not much you can do about it. That's right, or their lawyer will look at it. So, for instance, if you gave that child a gift of $500,000 previously in your life, or say only $100,000, if that's written out, then we have the evidence right there of what the rationale was behind that. And actually, when you look at it that way, now we see that all children are actually taking equally.